An Illinois court has reversed a $60 million verdict against baby formula maker Mead Johnson over claims the company failed to warn that its products for premature babies could cause a deadly bowel disease. The reason? The jury wasn't properly instructed on the law the company is accused of breaking. They were improperly told that the company had a duty to warn the mother, which impacted the trial.
A spokesperson with Mead Johnson says this lawsuit's claims are not supported by the scientific consensus or the medical community, a fact underscored at trial by the testimony of a dozen neonatologists. Joining us this morning, our chief legal analyst, Khalif Rhodes. Khalif, good morning. Okay, I realize science is not necessarily our backgrounds here, but when you look at this straight legal standing, what's the law that's talking about? What's the information that wasn't?
Well, the good part is we can say that science, and I give Mead Johnson and their legal team a credit for attempting to, attach themselves to this victory, and then also throwing the scientific aspect on there. But that's not what the court ruled. With the Court of Appeals, they didn't say your argument at the trial level was accurate. They didn't say your dozens of scientific experts that you brought in, that it was accurate and that the court got it wrong. What they said is that, and this is extremely important, you have to ensure that when you submit the jury to the jury room, before they go and deliberate, that the jury instructions are accurate and they are delivered accurate by the judge. What this Court of Appeals said is that the jury instructions were inaccurate, and specifically that the duty to warn, the standard, and who they had a duty to warn, as Andy said in the intro, was given, they placed the burden on the duty to warn to the mother as opposed to the duty to warn to the doctors, not the doctors that were testifying, but the doctors that are having interactions with the patient. So even if you have a dozen doctors come in and say the science doesn't support it, you're still going to have a requirement and a duty to inform the parents that are using this material that they have this out there. So that duty, if you guys aren't even giving these doctors that, because now you're saying the science doesn't support it, and second trial, you'll probably still lose.
Okay, so when we talk about where jury instructions come from, who's really in the wrong here for not doing their job, for giving the proper instructions? Because of a jury, we're not experts in the law. We're supposed to be given clear instructions on what to talk about. So who's responsible?
Yeah, that's a great question. I mean, any trial that I've been on, there will be a jury. You look at the pattern jury instructions, right? And both sides will come and they'll submit their proposed jury instructions to the judge. You'll have a conference, a mini hearing to say at some point while the trial's still being conducted outside the presence of the jury, where the judge will bring in the parties and say, hey, these are the ones that we want in and this is why. How do you want me to craft them if they're going to be away from the way that these instructions look? If you want some other one that I'm unaware of, give me the reasons why, give me the law that supports it. So this isn't something that happens overnight. This isn't something that happens quickly. This is something that's going to take time. The judge may say, hey, we're at this point of the trial. We think we'll end here, so let's start working on these instructions and submit them. That process is a process that's going to be vetted out. And so who's responsible? Everybody. But ultimately it lands on the judge, that the judge is going to be the one that gives the rule of law, that gives the instructions to the jury before they discharge them to go and do their duty, their jury duty. And so I'd say it's a lot of folks that create them, but the judge has to make sure that they are accurately submitted and delivered.
So what do you think happens now? And do you think there could be a different outcome the second time around? What would need to be shifted in the approach for a different outcome?
I mean, a different outcome. I mean, you'd have to have given the instruction that the requirement to warn, or the duty to warn, was the duty to warn the doctors, and now the plaintiffs would have to show that they failed to warn the doctors. And so it shifts their entire strategy, because now their entire strategy before was they didn't warn the mother. I mean, this is a terrible scenario. This mother lost her child, and so they were able to point to that and not get the sympathy from that, but recognize that if this mother would have known, then maybe this could have been avoided, and that strategy obviously changes now. On the other side, I mean, they have Johnson Mead has a number of cases, Mead Johnson, I should say, has a number of cases across the country where they're fighting litigation on these same type of things. So you got a couple paths. Yeah, you recognize that you won this and overturned this $60 million settlement. You can go fight it. You as in the plaintiffs could fight it to the Supreme Court level, or they can go back to the trial court and fight it again, or they can get back to the settlement table and say, hey, we did this once. You saw that you lost $60 million. Maybe we come back and we settle for a different amount so we avoid the cost of litigation. There's 3 paths to this, but at some point they all connect with going to court or some form of court.
Is there a path you see that doctors would be involved of like, hey, Mead Johnson, you didn't tell doctors about this, therefore the doctor didn't tell me. Does the doctor get wrapped in there somehow, or are they more protected because of really strong laws?
I think that it would be extremely hard to put a doctor and put them in this case, and that's why they went the products liability route as opposed to the medical malpractice route, because you're going to have to figure out what the standard of care, what would another doctor in that situation do. I mean, this is not like they're prescribing medication. This is a formula that you're using to feed your child. And so I would say that it would be extremely hard to connect them to some liability. This is the straighter path from a strict product liability. Anyone that's in that chain of distribution, anyone that creates it, manufactures it, delivers it, can be held liable. That's going to be the cleanest path to get there.
All right, Khalif, thank you very much. Appreciate that. A couple more topics with Khalif coming up through the next hour and a half or so.
Queen City News Plus. Just search Queen City News on your smart TV's app store.